today's episode of the Habitz Podcast, we've got Chris Aldridge, and he'll be sharing with us his good habits when it comes to intellectual property law. So thanks for joining us, Chris. I've got some experience with IP with my previous business. So for those that are tuning in and don't know quite what it is or what you do, why are you our guest experts?
So intellectual property is protecting ideas. So it's protecting brands and trademarks, it's protecting inventions and getting patents in place, and it's protecting the aesthetics in products, so protecting designs. I've been working in intellectual property for over 20 years. I've protected ideas, inventions, brands for hundreds, probably thousands of companies. I've got patents granted for companies like BMW, Google, and then for lone inventors and SMEs as well. And I've protected some fairly large brands.
So imagine doing this for 20 years, dealing with so many brands and dealing with all different types of IP. You see a lot of people that make common mistakes or have got a misunderstanding about what it is they can do to protect themselves.
So one of the first things that people do is they like to talk about their ideas and their invention. And that is a big no-no. One of the problems with doing that is that you won't be able to get patent protection for your invention if you've disclosed it to anyone before we file the application. So talking to your mates down the pub will absolutely ruin any patent protection you might have been able to get. Putting it on the internet is an absolute disaster. A lot of people like to talk about things, and that's the worst possible thing that you can do when you've got a new invention.
I can imagine that's quite a common problem, because I know most people, especially when they've invented something or something's new, they want to talk about it, they're excited, they can't wait to tell all their mates. And I would have thought that you could still get a patent even if you had told someone.
No, this is one of the big problems, because to get a patent granted, we've got two major hurdles to overcome. We've got to have something that's new, which means no one has ever disclosed it anywhere in the world before we file the application. And it's got to be inventive, so not an obvious combination or modification of known technology. That first hurdle applies even to your own disclosures. If you post a blog entry on the internet, that's destroyed the novelty of your invention. You can't get a patent for it.
So talking too much, I imagine that's quite a common one. What would the second thing that many people get wrong be?
A lot of people don't appreciate that they have IP when they do. And there's a lot to this, including brands, for example. If you think of what's happening at the moment with Boohoo buying Debenhams for £55 million, they're not buying the bricks and mortar. In fact, that was explicitly excluded. What they're buying is the brand. They're buying the trademarks, the goodwill in the company, and they're buying the IP that exists in that. It's much more than just buying the stock. And there's the designs as well that are also protected by intellectual property rights. So a lot of people don't appreciate that they have a brand that's worth something. They've got goodwill, they've got designs that they could protect, and also inventions. A lot of people think that something has to be high tech to get a patent granted. And this is kind of my third point, that you don't have to have something that's super duper technologically advanced to get a patent granted. I've got patents granted for clothes hangers, for shoelace holders, hairbrushes. It can be simple technology. It can be a simple bit of plastic, and still we can get a patent granted for it that will lock people out of your market and give you the protection you need to boost your sales and get a dominant position.
So hearing that now, there might be some businesses out there thinking, I didn't realize we had something worth protecting. I didn't think we'd need to understand about intellectual property. So what would be some of the good habits that a business that has got something that should be protected be doing or putting in place?
Well, there's the first things like keeping it quiet and making sure that you register a trademark for your company name, because having a company registration is not enough to stop other people from using the brand. So one of the key things is identifying the intellectual property rights that you've got, either as an individual or in the business. If you don't identify them in the first place, it's incredibly hard to then protect them and then beyond that, enforce them. Second good habit is you need to have a plan. Why do you want to protect your rights? What is it you're looking to do? Where do you want protection? You're just going to operate in the UK, are you going into Europe, are you going to the US? You need to have a plan, and not only have a plan, but share that plan with your advisor. Because yes, we can get you a patent, but then what are you going to do with that? Is it for tax reasons that you want a patent? Is it to stop people from copying your product or your method? Is it to get some world domination? You've got to have a plan, and you've got to share that.
I always see a lot of patent pending. Does that mean that they've not quite gone through the complete process, or does that mean they've got a product coming?
So when you file a patent application, from the moment it's filed, your filing receipt and your patent pending. So it doesn't guarantee that there is going to be a patent granted. I could file a patent application for a chair, but there's no way that that's going to get granted. I can then use patent pending. No one can see what's in that application for 18 months. It can be a bit of a marketing ploy just to deter people from copying the invention.
And what would your third and final good habit be?
The third good habit is to my mind, quite important. You've got to get on with your advisor. When you file a patent application, it could go on for 1 year to 8, 9, 10 years to get it granted around the world. So if you don't get on with the person that's advising you and getting this protection in place, that's going to be a very long 8 to 10 years. So you've got to get on with them. You can't be scared about asking questions, however silly those questions might sound. Believe me, I've heard some very strange questions. You can't be scared. You've got to get on with them. And you can't be worried about picking up the phone and then getting a huge bill. You need to be able to speak to them without getting a bill for several £100 for asking a simple question.
So if I'm listening to this now and I'm thinking, do you know what, I'd never realised that I had a brand, or I've not got a trademark for my business, and I want to talk to somebody about IP and how to protect myself, where could we find you?
It's easy to find me on LinkedIn. The company is Mohan Aldridge Sykes. We're on the internet and Twitter and everywhere else that you might want to look. So it's easy to find us.
So that was Chris sharing with us his good habits when it comes to IP law. Are you a talker? Have you got something that you don't know needs to be protected? If you have, don't forget to get in touch with Chris and join us next time for some more Habitz Podcast.